I just want to add some words to that because I think it actually is a good point of contrast here. My opponent just referred to the so-called trigger provision that we put into the original funeral picketing statute. It was a provision that said that the law didn't become effective, at least in the buffer zone provision. It did on the civil cause of action, but not the buffer zone provision, until there was a finding by the State Supreme Court, if memory serves me, that it was constitutional. And it was edgy in a legal sense at the time we did it. The reason we put that in there is because absent that, we were unable to get enough votes in the Kansas legislature to get the thing moving, because there were concerns among some key legislators about the constitutionality of the statute, and they were worried about the civil rights litigation that could arise should the state try and lose and be subject to a federal action and ultimately have to pay the Phelps damages. So we talk about experience. It is important to have experience in the law. It's also important to have experience in the process of creating the law so you understand why the pieces fit together the way they did. By the way, when we were crafting that provision, my opponent hadn't been appointed to the office yet, but his predecessor was there. General Morrison actually came over, sat down, and we worked through the language. Unfortunately, it wasn't appropriate.